Okay, welcome everybody to the Vocational Science of Freedom Wednesday night open roundtable. And tonight I'm going to cover over the entire VSOF Status Docs process. I'll go through each document, what it is, why it was created, the order that you file them in, and the procedures that have to happen post and prior to getting your doc set done. Now, as far as the totality of the Vocational Science of Freedom Status Doc set, why do you need to do it at all? So let's go through the 5 W's. First off, the why is that there are dozens of presumptions that the corporate state and the attorney use against you, whether you're in an inferior court, whether you're signing a document for them, whether you're begging them for a license. The language in all of these documents, when you're dealing with any Roman civil law, also known as municipal law, is very confusing for most people. And they don't even know what they're stating when they sign something, because in these documents, what the corporate state will do and what the attorney does is that they'll put you into a status inside the document that you're not even aware that they did. And then you sign it, which then is a confirmation to them and a presumption that you have consented to being governed, is the core of what this is. And the system of slavery that they've developed around this, the way of using words like that and the way of catching people and placing them into contracts or pledges that they didn't even know that they were entering into. A good example, that's the signing of the birth certificate contract at the hospital that your mother and father do. Again, that's a very good example of how they do this. For people that have not joined the Gilded server yet, the description of how to join the Gilded server is in the description of all of the videos on the Vocational Science of Freedom YouTube page. You can also click on the About section and you can go down to the links in the Vocational Science of Freedom Gilded and click on that, and you can then join the Gilded server. When you get to the Gilded server, make sure that in the upper left-hand corner of the banner, make sure to click apply, not just follow. So you click apply, and then you'll be asked to answer some pretty basic, simple questions, of which there's no right or wrong answers to, but we just want to make sure that people have a general idea of what they're getting into. And it also helps me to filter out agents and provocateurs that would otherwise come in here and cause havoc. In the National Popular Assembly classroom, I put the links for the live stream for tonight, which we stream off of YouTube, so you can go back and look at it later. It's not published, it's unlisted, so you have to have this link to be able to see it. And then I also put the mega folder that has all of the handbills for the Vocational Science of Freedom Status Doc set, which is what we're going to go over tonight. I'm going to go over 3 of the major ones. I'm not going to go over each handbill for each document, but I will show you guys where they are at so that you can take the time to go and learn what each document is and why it was created. These 3, if you click on the link, and I'll just go ahead and do this to show everybody how this works. Click on the link, it'll open up the mega download site, and then you click on handbills, which is the first folder. The documents we'll be going over tonight are number 2, VSOF total plan to settle the estate. So number 2, handbill for status docs description. Or it'll basically have a table of each doc, and then I have a short description of each document in there, which I'll go over in more detail. The printable checklist of what you need to do, it's basically a check off sheet, and I believe that's in the previous folder. So printable checklist for status and estate documents, and then you click on the handbill folder, and it'll be the other 2 that I just mentioned. And anybody can get onto the mega link. I mean, if you're watching on Odyssey or YouTube, you can, if you'd like to, just go ahead and type in that whole long link if you want, but the link is in the Gilded server, so all you have to do is just join the Gilded server, click on the National Popular Assembly Classroom Voice, and then just click on it here. Now the other places, and this is what I wanted to explain to everyone else that's on the server or watches this later, the links are located in a logical place. I mean, I know there's a lot of stuff that we have on our Gilded server, but if you go down to the Vocational Science of Freedom information section, or I guess they call it categories in Gilded. So you go down to the VSOF information for categories, and you click on either membership and prices or correct your status. But if you click on membership and prices, you can scroll up to the top. The mega link that I just opened up is this same link. If you click on correct your status and you click on how to get your status corrected on the public record, the handbills are also listed in the mega links in that room, or that post for that room as well. Okay, and then there was one other thing I wanted to mention about under the correction or correct your status. In the VSOF information room, so you click on correct your status and then you click on how to get your status corrected. If you scroll down, what I did was, because this has become kind of an issue as far as people not fully understanding the whole entire process and the order of which it needs to be done and why it needs to be done in a specific order, meaning the things that you have to do prior to having the VSOF fill out your doc set, and then the order of which you need to file your doc set in. There's a very specific logical order that they need to be filed in a specific order. You can't just say your birth certificate claim without having gotten your birth certificate authenticated at both the state and the federal level, because you have to attach it to that document when you file it into the public record. What we're going to be making sure of today is that no one's putting the cart before the horse. No one is taking things out of order, and so that no one's missing anything. And then also I'll cover a little bit at the end about what the all-day class will be in June. I was going to have it in May, but last weekend there was a scheduling conflict with a lot of people in Utah. This coming weekend is going to be Memorial Day weekend, so I didn't feel it was appropriate to have the class on Memorial Day weekend when most people were probably going to be going off and enjoying the weekend with their families. So what I'm going to do is I'm going to reschedule it and have it for the first Saturday in June. It'll be a whole entire day class on what to do after you've gotten your status docs done, because I don't need to cover a class about what the Vocational Science of Freedom Status Doc process is, because I already did a class on that. And since there's been this kind of level of confusion about what should be done and in what order, I posted that class in here under correct your status, because I figured everybody that's going to get their status docs done, they should go through and be able to have access to this class. I did open the class up for everyone because of this problem that we were having regarding that I'd done this class, but that it wasn't accessible and that people didn't know where it was. So I put it into this section under the VSO information. So if you guys go through, and yes, these 4 YouTube links they constitute for an entire day of class. So it might take you a little while to go through them. Let's get started with Handbill of Status Docs description. These are just the short descriptions for the status and estate documents. This is what each little thing is in a very, very abbreviated couple of sentences. This is the name of the document down the left-hand side here, and then the second column is the description of what the document is, what it does for you, why you need to file it, what is contained in the document, and what other docs are connected to it and why. Pretty much. But I wanted to make a very, very simple explanation so that I could just give it out to everybody so you get the gist of what's going on here. In the beginning, why are we doing all this? We're doing all this to establish our own house. Now, under Roman civil law, and this predates Roman civil law even, this goes back into the ancient world, the house was the first subdivision of political society. And you can see this not only in biblical writing, in a lot of passages in the Bible, you can also see it in a lot of law documentation, whether it be Roman civil law, Babylonian, or in some cases what is still left over from certain aspects of Egypt even. And also from other ancient civilizations that lived around, that existed before and after, the ones I just mentioned. The establishment of one's house. Under Roman civil law, there would be the Roman citizen who had their own house. Then there would be the slave families who lived under his house, and they had what was called familiar names. We now call them family names. Just to make a point here, people who put down in their documentation, meaning things that are akin to documents like this, that put down in their documents, oh, family of so-and-so, you literally just called yourself a slave under Roman civil law, and you didn't even know it. Why am I bringing this up? I'm bringing this up because there are so many things that are so important to do right and correct that that are all finished and they're all done in the doc set, that I've had a lot of people, and of course this is just something that I expect anyway. I'm sure it's never not going to be an issue. But as of late, there have been more and more people coming to me and saying, well, why can't we do this? Or, well, do we really need to do that? Or is it required for us to do this part or that part of it? The answer, it's just going to be yes. If I have set down something that needs to be done in this doc set, in the process, it has to be done for a reason. I did not create this doc set and spend 25 years of my life creating something that I just thought was a bunch of shit that I'd throw against the wall and see if it stuck. Each and every one of these documents has a very specific reason for existing. Each and every one of them does a very specific and different thing. Each and every one of them has been researched thoroughly. Every word has been looked up in Bouvier's, and some of these documents have gone through up to and over 100 revisions and edits over a 15-year time frame. So what I'm saying is, if you think, or if you come to me with some sort of argument thinking that you can do this better or that there's something that was missed, if it was something that you think was missed, I'll take it into consideration because nobody's perfect. But if you come to me with an attitude that you think you're right and I'm wrong, well, then you can just go do your own paperwork. You don't have to use this one because I'm not going to be the one that comes and helps you out when you come crying back and screaming to me that you're in trouble because you altered something or you didn't do something that I told you to do. I don't have time for that. There's too many people in this world that are enslaved. I am focusing on removing that condition of slavery for all of my fellow Americans. Those who have perpetuated this slave system are the same ones that perpetuated the slavery of the black people during the colonial times. And it's the Khazarian mob. Okay? And if people would understand the history of who these Luciferians are and why they do what they do, a lot of things would become very, very clear. Now, of course, that's a whole another class and a whole different subject, which I will be going over much more extensively on Saturday nights, particularly now that we've gotten into banks and banking, which is why those lectures are not going to be put onto YouTube. I'm only going to upload them onto Odyssey because I am going to tear into the Khazarian mob. All of the things that you never knew, the things that you're not allowed to talk about, all of it. I'm going to lay it all out. To put that aside for a second, just to get back to this. We're establishing our own house. Now, yes, like I said, the establishment of a house pre-exists Roman civil law. So do not think that we're doing this to be compliant under Roman civil law. That's not the reason whatsoever why this is to be done. The reason it's to be done is that you need to establish your own house. The male needs to establish his own house so that his children and his wife are protected under his law as one of the people, meaning that he's sovereign, in a constitutional republic. Now, to start out with the seal, why do we need a seal for our own house? There is a section in the original Illinois Constitution, the 1818 Illinois Constitution, which I will show you guys right now. The importance of it is that it proves to everybody, that at one point in time, and this was not all that long ago. Yes, 1818 is a while back. However, we're not talking about ancient history here. We're talking about the establishment of one of the constitutional republics in the Union. 1818 Illinois Constitution, scroll all the way down to the bottom. Okay, all the way down to the schedule. Now, you're only ever going to see schedules in the first original constitutions for each state. And the reason is because the schedule is what they lay down in the Constitution to get this thing going. So we've written this Constitution. All right, how do we implement all of this? That's what is contained in the schedule. So I'm just putting that out there so you understand what this is. So I'm not going to read all this. I'm just going to scroll down to number 6. Number 6, the governor of this state, lowercase s state, shall make use of his private seal until a lowercase s state seal shall be provided. Okay, now what does that mean? It means that they didn't know who was going to be governor. But whoever it was going to be, the presumption was that they would have their own seal. Think about that. That in 1818, everyone had their own private seal. At least a man that would have been eligible to be elected governor of Illinois in 1818. Clearly shows that we all used to have seals. Okay, where'd it go? Why is no one using a seal anymore? Why are we not creating our own seals? Why do we not, have an establishment of our own houses anymore? Well, short answer to that is because the Prussian education system, which has been slowly destroying every single lesson and fact regarding American civics and regarding the study of one, because civics is the study of one's rights. That's the definition of civics. It does not mean the study of American government or the study of the United States government. It means the study of one's personal rights. That's what civics is, and that's what we teach here. It does not mean how is the government organized and how the laws work. No, that's a part of learning what a constitutional republic is, but it is not in and of itself the essence of what civics is. Civics is the study of one's rights and how you go about exercising them. Because as the maximum of law states, he who does not exercise his rights has none. If you don't exercise them, you don't have any. To get back to the seal part, whoever it was, they knew that he's going to have a private seal until a state seal shall be provided. So the state has its own seal. Okay, why? What's the state creating? Guess what? The state is creating its own house as well. What do you think the House of Representatives is? If you are not under the law of your own house, you are under the law of the House of Representatives, being administered as an infant, as a person, under Title I, subsection 8 in the United States Code, under the definition of person, which I've gone over many times, so I won't rehash it here. That's the point. That's why you have to establish your own house. That's why you have to have your own seal for your own house. Now, there's another old statement, or another old saying, I should say, that goes right along with this. And that is, and everybody knows this, but they don't think about it. When you say, oh, that's been signed, sealed, and delivered, what the hell happened to the seal part? Now it's just signed and delivered, but we're not putting a seal on it? And the importance of a seal is, it goes deeper than just what we're talking about here and about the establishment of the house. When you use a seal on a document, it alters the document from being just a contract to being what's called a covenant. I'm going to grab out of Bouvier's Law Dictionary right here just really quick and show you guys what the definition of covenant is. Now, I'm probably not going to read the whole thing because it's probably going to be fairly long, but it might not be. Okay, so here it is. So there's a lot of different things regarding covenant. Obviously, you see all these entries. So, covenant, contracts. A covenant is the most general signification, means any kind of promise or contract, whether it be made in writing or by parole. In a more technical sense, and one in which it is here considered, a covenant is an agreement between two or more persons entered into in writing and under seal. That's the point. Whereby either party stipulates for the truth of certain facts or promises to perform or give something to the other, or to abstain from the performance of certain things. Now we'll get into the specifics of that when we get to the kill warrant. We get to the KW, and I'll tell you the whole technical title of the KW. I mean, that's just what we refer to it here, because the document itself has a fairly long title. So we just, at the VSOFs, we just call it the KW, but I'll explain to you what the full title of the document is. Anyway, under that document is the one where we're saying to literally the entire planet, everyone who is not a member of your own house, you are offering them the position of being a trustee of your estate. Now, how do they enter into being a trustee of your estate? Of which, by the way, you're the executor, which is another status doc we'll get into later. The point is, you're the executor. You're offering this appointment of trustee to the entire planet, everyone on it, and even technically anyone who's not on the planet. Anyone who administers your estate, who's not a member of your own house, automatically then gets placed onto and into this covenant because they agree by their actions to be a trustee of your estate. Now, how does this work and how is that lawful? Think about this for a second. Say you had 20 acres of land, and say it was some long rectangular thing, right? Every day you're sitting on your back porch and you see a guy jump your fence, walk across your land, and then jump the other fence to go off to go do something. And you think, you know what? I don't want this guy crossing my land all the time. I don't know who he is, and I don't know what he's doing. So you go down there, and you put on the side of your fence all the way around all of your fences, which is, by the way, where your dominion starts. Your dominion is a Roman civil law term regarding what you have authority over. Your dominion is within the boundaries of your fence. So you go and put out no trespass. You say, no trespass upon these lands, and if you're found to do so, then you willfully enter into the following contract and say that he owes you, whatever you put down, because it's your law. You can write it however you want. So say he owes you 4 ounces of gold or something. Per each trespass, the trespasser will agree to pay the owner of said lands 4 ounces of gold. Say that's what you put down on your trespass sign. That's notice. Particularly if you say on the top of it, notice, no trespass, right? Which is how most of those signs, well, here's the thing. Most of the signs that you buy at some store, Lowe's or whatever, Home Depot place, it'll always say no trespassing. Well, there is no such thing. Surprise, surprise. Why do you think they write the signs like that? The proper way to write the sign is no trespass. So notice, no trespass. You put the contract down and you say, okay, great. Now, if someone chooses to trespass upon your land, they have then entered into that contract. Say the next day you're sitting out on the back porch again, but this time you got a couple buddies and you're grilling out or something. You're having some beers and you see the guy coming. And you're like, hey guys, look, here he comes. Watch him. And all 3 of you watch the guy jump the fence. So the 3 of you go running down there and say, hey, you just entered into a contract. Guy goes, I don't care. Say, well, we put this sign up yesterday. You've entered into it, and all 3 of us are witnesses to you trespassing upon this land. And he goes, I don't care. Well, 3 of them hog tie the bastard, throw him into the back of a truck, and take him to the nearest, most accessible magistrate. And I don't care if that magistrate's 2 blocks away. You take him to the nearest and most accessible magistrate. And I don't give a damn if it's 4 o'clock in the morning. Same thing applies. You take him there and you say, look, I have 3 witnesses. This guy trespassed on my land. Here's the trespass notice that is on my fence that all 3 of us witnessed him read, Your Honor. Now, what that magistrate's going to do is he's going to read that and he's going to go, you owe this man 4 ounces of gold. Now, if you wanted to take it to trial and you wanted to tell a jury of 12 the same thing, you could totally do that in a court of record. That's fine. But what the judge is going to say, or the magistrate is going to say to the trespasser, is that this is a valid contract and you do owe it. So you're the one in dishonor here if you don't pay this, because that's a lawful contract. Same thing would apply. Let me put the story a different way. Let's put it with no criminal intent here. Let's say I wrote a contract out that said, I'll paint your house for such and such amount in gold and silver, whatever. But I do not enter into the contract until I pick up a paintbrush and start to apply paint to the side of your home. Say that's how we wrote the contract out. We both sign it, we both seal it, both put our house seals on it. Okay, great. Now, I don't show up for 3 months. And you're like, said you're going to pay my house. You haven't shown up for 3 months. I'm like, well, I haven't got around to it yet. Like, well, I'm going to sue you because you haven't fulfilled the contract. You're like, hey, great. No, whatever. And so you go to the court and you point out the line that says, when I touch a brush with paint on it to the house, does the contract then activate? The judge will look at that and be like, did he ever paint the house? Asking the other guy. And the other guy will go, no. And the judge will go, bam, case dismissed. Get out of here. Because the contract says that the contract doesn't attach to either party until the paintbrush hits the wall with paint on it. Okay, that's exactly what we've done in the KW. We've said, look, we've offered you the trustee position. You don't have to take it. Meaning, you can stay the hell away from me. You can stay the hell off my land. You can stay the hell away from my children. You can stay the hell away from all the rest of my property, including my body and everything else, which is a ridiculously long list, which we put into the KW itself. I mean, the list of things that are considered part of your estate is like 2 pages, maybe even 3 pages long. We've made sure it was extremely thorough. Now, if they administer any of that, they've stuck themselves. They've then entered the contract by their actions. So they've activated the contract. So now they have adhered, that's another way to put it, they have now adhered themselves to the contract. And that is exactly what the arbitrator said when Drew put his KW into binding arbitration against the judges. The arbitrator said, yes, the judges entered into the contract because they were served with the contract prior to any other contract superseding it. So they didn't have to go through their stupid Roman civil law system of attempting to, or think that they had the right to, administer his estate through basically probate, because all of those inferior courts are running through probate. They won't tell you that, but we found judges' books, judges' handbooks, particularly one out of Georgia, that said right in it that they're running traffic court through probate. Well, what? Why would they run traffic court through probate? Because it's not about law. It's about the administration of abandoned infants' estates and the property thereof. The res, I should say. The res of abandoned infants' estates. And you're that infant because you have not claimed your title. And you have not claimed your estate. Because an infant cannot hold title. You have to get rid of the infancy presumption before you can even hold title, which is why, and now we'll go back to, now that we've covered covenant here. Well, I'll cover this one last part here. So under seal, whereby either party stipulates to, okay, so I read that. Number 2, it differs from an express assumpsit in this, that the former may be verbal. So an express assumpsit says, hey, I'll pay you Tuesday for whatever, right? Or in writing, not under seal, right? So a covenant differs from just a verbal contract or something not under seal. When the latter must always be by deed, meaning something under seal, right? In an assumpsit, a consideration must be shown. Okay, so meaning a consideration, meaning what? Something that's worth of value. Do Federal Reserve notes have any worth of value? Do they have any consideration? The answer is no. A Federal Reserve note has no consideration. This was proved by a jury and agreed to by a judge in what was called the Jerome Daly case. Some people also refer to it as the Credit River decision because it was done in, I believe, Credit River County in Minnesota. And in that case, they found that Federal Reserve notes have no consideration. So where's the consideration here? Right? So if you don't have it, you don't have a contract. Okay, so it says, in a covenant, no consideration is necessary to give it validity, even in a court of equity. So get that. If you've created a covenant, meaning something that has your seal on it, no consideration is necessary to give it validity because you're above that. You're literally above it. So you've created a contract that, and it says in the contract, in the KW, that they will get consideration if and only if they perform as you wish them to as the trustee regarding your estate and property thereof. They do have a carrot stick. I mean, there's a carrot on a stick in the KW saying, if you do this, you will get paid from the estate. If you do not do this, and you do any other administration other than what I've demanded that you do under this contract, which you've just adhered yourself to, then you, meaning them, the trustees, they have to put up a $300 million bond for potential fiduciary malfeasance of your estate. Now, I thought that was pretty reasonable because when we've gone through and looked at the BC audits that were done through the Bloomberg terminals, which I'll also show you guys where that information is and how to get hold of the company and how to get that all done. But most of the fidelity bonds that came back that were attached to people's birth certificates were anywhere between 100 million and like 250 upwards above 300 million. So I thought 300 million was a nice number because there may be a few people that have bonds that are above that, but no judge is going to be stupid enough to put himself up against $300 million of liability. There's another gentleman who does some other fun things with bonds. and his name's Cal Washington. What Cal does, and he runs, by the way, if you want to look at Cal Washington's work, go join the Empower movement, where he teaches people how to get smart meters off the side of their houses. How he does it is basically puts them under liability as well. But the other thing that he does, when he goes to court, he bonds his own case. And he always bonds it for twice as much as the other side has basically set the bond amount for their case. Then he puts that into the court case, and then basically the thing just disappears. They're like, no, okay, you know how the system works. We're not going to play with you. Instead, what I do from the standpoint of the bonding is that I'm not bonding the case. I'm forcing them to put up a bond to protect my entire estate because they're the ones that entered into the contract as a trustee. It's the same use of the weapon per se, but in a different way. Okay, so that's covenant. That's the importance of the seal. And so now let's get back into, and that's the schedule, the understanding of the seal from the Illinois Constitution. And now let's go through now the handbill description. The one is labeled 2, Handbill of Status Docs Description 1.1. Handbill of short descriptions for status doc and estate documents. So the things listed in red down the side here are separate services from the Vocational Science of Freedom status doc process. Like, just scroll down at the bottom. To do the SS4 form and the Declaration of Allodial Lands, there are separate amounts that I ask for doing these two things. They're not part of the whole rest of the status doc process. And then things in purple are the things that you should have the authenticated BC attached to them. Now, if you've only gotten, or when you sent off to get your birth certificate authenticated, you only got one copy of it, it's okay. The process can still be done, but I tell everybody that you should get 3 copies of your BC authenticated at both the state and federal level. The first thing is you got to make your house seal. What you do is you can either go to a office supply store and get them done. They cost about anywhere from, I think the lowest I've ever seen somebody get a seal made was like $75. And the most expensive I've ever seen a company asked to get a seal made was like $250. So, or you can go to an Office Depot or whatnot, and they will have a form that you can fill out. And what you've got to do is you've got to go down, and this is, by the way, this is all explained, how to make your seal, and all the rest of the stuff is explained in the mega folder under VSOF prices and handbills. So when you go into the handbill section and you go to the handbill of how to make your seal, which is in folder number 2, says do this second, how to make your house seal. You can read this handbill. I'm not going to go through the handbill because, like I said, I'm not going to go through the individual handbills because I've already done that in the class. But this is just where it is, okay, is to go and look at here and to get your seal made. Follow the handbill, get your seal made, then authenticate your birth certificates. So what you want to do is go down to your birth county, wherever it was, or if you don't live there, then just call them or send them whatever they want for the amount of copies of a birth certificate from the county. And then what you do is you go to the Secretary of State's website for whatever state you're from. In the mega link section, I've got California, Colorado, Connecticut, Illinois, Iowa, Massachusetts, Michigan, Texas, and I've got Wisconsin, and I've got also the U.S., the federal forms. So what you do first is you go and you get them authenticated on the state side. Now, California and Colorado will only give basically an apostille. The point is what you want to use, what you want to tell them. And technically they're not supposed to do this because if you give them the name of a country that's not a member of the filthy Hague, which is basically the preliminary of what they want to set up as the world court so that they have the one world government. What you have to do is you have to pick a country that's not a member of the Hague. If you pick a country that is a member of the Hague, they'll say, well, we're only going to give you an apostille. And that is even for states that will do authentication. If you give them the wrong country, they will not give you an authentication. They will give you an apostille. And there is a huge difference between the word authentication and the word apostille. And you can go look them up in Bouviers. I'm not going to go over it right now. You want an authentication because you want this thing to be as good as the original. Also in this folder, I have in folder 1.5 what you get back from the Secretary of State. And I made a document as close as I could possibly make it to make it resemble what this piece of paper looks like that you get back from the Secretary of State. Now, this piece of paper it'll be on almost like on card print. It's a very thick piece of paper. It doesn't come on white. It comes in light brownish colored paper. And this is everything that exactly says on this authentication. Now, back then it was John F. Kerry was Secretary of State. Obviously, this is several administrations ago. This section of law down in the lower left-hand corner is what's most important about what is on here. Now, I've had the argument from people saying that, well, it's in a box. That means it's not really on the paper. Okay, I understand that. I understand that about formatting. I understand that about style manuals. I get it. However, even if they put this in here and they put it in a box and are saying, well, it's in the box and it's not really, dealing with this actual document, the fact that they gave me the law is all I needed. Because what it says in the document, it says, I certify that the documents hereunto annexed is under the seal of the state of Wisconsin, and that such seals are entitled to full faith and credit. For the contents of the annexed documents, the department assumes no responsibility. The certificate is not valid if it is removed or altered in any way whatsoever. Meaning, if you go to get your status docs recorded and they try to remove this authentication from the BC, meaning they tried, because it gets riveted to it. It's not like they just put like a little piece of tape over it or they give it back to you with a paper clip. They put a solid rivet through it so it cannot be detached from it. I've seen some idiot clerks mess with it or try to take it off. And I said, if you break that rivet, that's a felony. And they're like, what? I'm like, you cannot break that rivet. You cannot separate that document from that authentication. I said, that would be destruction of a public record, and that would be a felony, and I will make sure that the Justice Department knows about it. And they just backed right off. Most of these people are stupid. They don't even know. They're just like, well, it won't fit into the computer. I've got to tear it off. No, don't touch it. Fold it over, scan it, and go on to the next page. Because you got to make sure that the BC and the authentication of the BC gets placed into the attachment as an attachment to the birth certificate claim. It's imperative. Because when you get this final authentication from the Fed side, the state one's not so important. It's the Fed one that you need, but you cannot get the Fed one until you get it authenticated on the state side. They won't do it unless you get it done both beforehand. So you got to get it done on the state side, and then you get it done on the federal side. Then you get this block of law on it. It's attached to it. This page gets riveted to it, and then you have a title that is as good as the original. Because in this little block of law, which by the way, I put the law into the folder. So if you guys want to see what these laws mean, I already took the liberty of going and looking up these laws for you and then putting it into a document. And most of them are at the bottom because this one was like extremely long regarding the code. But anyway, the rest of them are at the bottom. So this one, 22 USC 2657 is here. Custody of seals and property of Secretary of State, right? 22 USC, this one is here. Secretary of State, the Department of State shall be administered in accordance with this act and other provisions of the Secretary, basically meaning that Deputy Secretary of Management and Resources shall be appointed by President, meaning that they have the authority to do what they just did, which is put this authentication together. I have a few that I've missed here, but you guys are welcome to help me fill out the rest of it. And one is 5 USC 301, which I think, if I recall correctly, is part of FOIA. Then there's 1733, government records and papers. Books or records of account or minutes of proceedings of any department or agency of the United States shall be admissible to prove the act, transaction, or occurrence as a memorandum of which the same were made or kept. Properly authenticated copies or transcripts of any book, records, or paper documents of any department or agency of the United States shall be admitted in evidence equally with the originals thereof. There's the reason why you absolutely cannot, under any circumstances, skip this step. Because once this thing gets attached to the BC, the feds themselves had said that it is equal with the original thereof. Your original birth certificate is sitting in the DTCC, the Depository Trust and Clearing Company, at 51 Water Street, which if you walk through the door, look up. It'll say right above the door, Tower of Power. It's not a joke. That's also where Q said all of this stuff ends. He said this all ends at number 55. Those of us who knew what he was talking about were well aware. I doubt anybody else understood what he meant. But anyway, this authentication has to be done so it has this block of law in it. So it is as good as the original. And the fact that they say shall be admitted in evidence. If it shall be admitted in evidence equally, then when we do a coroner proof of life and proof of age inquest in our own court of record, we are showing that, yes, hi, I've been found to be living. Yes, hi, great, thank you. I've claimed my estate now. This is the importance of this information. Now, I know this is deep, but it's taken years to put all this together as far as where all this stuff was hiding. I didn't come up with this authentication process. There was a group of people, I think the group was called Tactical Sovereignty. I think the group is still around anymore, but I haven't kept up with them to see what they're up to. I believe they got this process from the Moors. So the Moors figured out how to do this first, then they gave it to Tactical Sovereignty, and then we got it. And I was like, oh, okay, great. Now we've got a way to get this thing authenticated. But when I got this back and got this block of law on it, I was like, oh, okay, I see why these guys did this. But that's the thing. Until you know why something's done, well, then you think you can skip it. That's the point. Don't skip it. And like I said, the law's in there. So take a look at what that says. Okay, that's getting the authentication done. So you got your seal done, got your authentication done. Both state and federal level. Then you do your declaration, establishment, and publication of house seal. This is what we were kindly referred to as the seal notice. So go look at the handbill for the declaration of house seal, which is this one. You can feel free to read it. So what does it do? It establishes your house on the public record and the seal thereof. It places a shadow of doubt on all other contracts that do not have that seal upon it. It gives the opportunity to all who are served with this doc to rebut what is stated therein within 30 days or to be bound to all that is declared therein. And it is also, as well as all the rest of the documents, is a continuation of your will. So that's the getting your seal notice. So you got your seal down and established. And by the way, the documents, as I said before, I'm just going to reiterate this because of the importance of it. The documents down the left-hand side here, meaning the process and everything, you have to file these in order. So when you take the stack to the county recorder's office and they say to you, do you want these filed in any order? You say, yes, I need them to be filed in the order of which I just handed them to you. Meaning first one on top, second one second, third, fourth, all the way down. That's what you got to tell them. And the importance of it is that because there are some places, some counties where you'll take the stack in and they'll give you one public record number for the whole entire stack. Now, there's technically nothing wrong with that, but it's better to have a separate public record number for each document so that you can refer to each document in paperwork when you're either administering the trustees or administering the inferior court or administering any other inferior filthy corporation. It's better to have them all separate. But if you do get a county, and you can, of course, you should ask them this first. Hey, can I have a public record number for each one of these? As far as the stack is concerned, no, they just give one public record number for everything. Don't argue with them. Just get the thing recorded. As far as recording is concerned, does it have to be recorded in your birth county? No. Is it better to be recorded in your birth county? Yeah, I suppose, but there's no alteration of the validity of the documents if they're not filed in your birth county. Like if your birth county is just an absolute, Ashkenazi bunch of bastards, then fine. Don't worry about it. Just go to some other county, get it filed, and then you can get a certified copy from whatever county you did file it in, and then take it to your birth county and file it into the public record under miscellaneous and say, well, these have already been recorded in such and such county. I just want them recorded here too. And basically what the proper way in law to tell them to shut up and do it is file on demand. You tell that to any clerk. I don't give a damn if it's a court clerk or if it's a county recorder. You tell them file on demand. They literally must obey you. If they don't, that is a denial of the access to public record, which again, you can slap them upside their head and tell the Justice Department to go get them. Which is why I always take a tape recorder and a witness with me whenever I go record anything, or if I'm dealing with a court clerk, because I want the witness, I want the recording, I want exactly what came out of their stupid, filthy mouths about how they think they're more powerful than we are, or what other bullshit came out of their mouth. that's wrong, according to law. Then, after that, I'm going to crush you. Because you are my servant. You are not above me. You're not my master. I own you. And not only do I owe you from the standpoint that I own you from that you're a trustee because you hold public office. I own you because if you attempt to do anything other than what I just told you to do under seal, guess what? You've just entered into the contract too. And then I'll take you for binding arbitration for $300 million and I'll bankrupt you. So shut up and do what I'm telling you to do. Now again, don't tell them to shut up because they'll get all freaky and they'll look, I'm going to call the sheriff, man, I'm getting harassed, whatever. If they don't file it, you call the sheriff. You call the sheriff and say, look, she's denying me access to the public record. All I want to do is just have this filed into miscellaneous. She has absolutely no business reading it. It just needs to go on to miscellaneous. It's already been filed into such and such county recorder's office 2 counties away. If she doesn't file it in the next 5 minutes, I want you to arrest her. And do it. Call 911. Right on him. Do it. I got an old friend, older guy, much older guy. He used to do this all the time. In fact, he still does it. In case if he ever goes to a public recorder's office and they screw around, he instantaneously dials 911. They're like, what are you doing? I'm calling the sheriff. Calling 911. Crime just was committed. What do you think I was supposed to do? Next thing. Birth certificate, seal, done. House seal, recorded. Next one. Once you've got your BCs done, and your BCs can be in process, meaning at the state and federal level, the thing that you have to get done, you have to have is your seal. Before you do any other of the doc sets, you have to have your seal, or you cannot do any of them. Also, make sure after you get your seal, make sure to go buy yourself the proper size little gold stickers that go onto the paperwork. And gold seals will come in like rolls, and you can roll them out and you'll see, they're just all stuck to the wax paper in an order, wherever. And by the way, when you go to copy the raised gold seals, because the way that copiers work, they basically work on the reflection of light. Because the gold seal is raised above the paper, it turns out very clear as far as when it gets scanned and when it gets run through a copy machine. It comes out quite clear. So just another thing, it's another side thing to let everybody know. Okay, so you got your seal done, you got your seal notice signed and sealed. For each and every one of these documents, with the exception of one, which is the coroner proof of life and proof of age inquest, which I should probably make a different color just so that people are aware of the fact that this is a specific one that needs more people. All the rest of these documents, you can have 4 witnesses, which is called a quorum. If you have 4 witnesses, it's just as good as a notary signing it, except when a notary signs something, basically what a notary does or ends up doing, this is something that happens, and it's just a matter of operation of law. They don't even realize they're doing it. Is that when a notary seals something, basically what they've done is they've counter-deeded. And if you go look up counter-deed in a Black's Law Dictionary, you'll see what I mean. They counter-deed your deed done. Instead of having counter-deeds all over the place and use notaries, what we do is we just use a quorum. And a quorum is 4 people, 4 witnesses that witness that you signed so-and-so. And that's just as good as a notary. All the documents require a quorum signing sheet, for the exception of the coroner proof of life and proof of age inquest. Because under the proof of life and proof of age inquest, what we've done is we've created a document where you summon a petite jury together to get the proof of life and proof of age inquest done and finished. The judicial coroner appointment comes before you do the proof of life and proof of age inquest. And to get the coroner proof of life, proof of age inquest, first you have to find a judicial coroner, someone who's willing to be a judicial coroner for your house. Now, basically what that means is that it's anybody, and that's under the handbill of judicial coroner, right? So I'm not going to go over it again. What it is that it's basically anyone who has a medical license of any sort. They could be a chiropractor, they can be a registered nurse, they could be a doctor, they could be a dentist, they can be a paramedic. I don't care. Just someone who has, under the corporate state, a medical license that says, yes, I'm a medical professional. So that the corporate state, can't question the fact that we have chosen a medical professional to be our judicial coroner. Now, why is this lawful? When you establish a court of record is the court of the sovereign. The substantive definition of court is the sovereign and his or her suit, which used to be called or pronounced suite. The suite were the numerous amounts of people that followed around the sovereign that remembered what happened in his court. Now, where is the sovereign's court convened? Wherever the sovereign is. When you establish your own court and your own court of record, you can appoint whoever you want to staff that court. Why? Because it's your own damn court. Now, this is all stuff that Bill Thornton taught me years ago, and I double checked it, and he's absolutely correct. We have our own courts, so we can establish our own judicial coroners, just in the same way that we can appoint our own special masters and our own marshals. And you can see that a special master is even, I mean, this is something that they even have still in the Federal Rules of Civil Procedure. Just go look up the Federal Rules of Civil Procedure and look at the appointment of special masters. It's in there. And that's Roman civil law, and it's still in there. We have the right to establish our own judicial coroner and to appoint them to our own house and to have them convene a petit jury for the coroner proof of life and proof of age inquest. What that is, okay, well, I'll do the coroner appointment. So this establishes your judicial coroner for your house. It is an appointment to an office of your court of record. Many states have removed judicial coroners, and therefore we need to be sure that we have an appointment for same to our own courts of record. Most of the time you'll see, instead of the words being used, judicial coroner of a county, now they'll just call them medical examiners. They've gotten away from even using the word coroner, let alone judicial coroner. The etymology and the history of the word coroner actually means the protector of the king's property. That's what a coroner is. Now, most people don't know that. Most people usually think of that term being more, or that definition being more akin to the connection with a marshal being the protector of the king's property. But a marshal is more the enforcer of the king's court. So after you get the coroner set up, then you proof of life, proof of age. Okay, so a formal proceeding, according to the common law, that proves on the public record, in your court of record, that you have been found to be living, you've come of full age, as per the Magna Carta, and that you're competent to handle your own affairs, and are not an infant under 1 U.S.C. subsection 8 under the definition of person. So it takes care of 3 of the largest, most egregious presumptions that the corporate state and the attorneys use against you. Then all 12 people sign it as a petit jury after the judicial coroner has convened the court, the reason why they're there. And here's the other thing, too, about doing an inquest, which I cover completely, again, in the class material about this, so you guys can go look at it in its totality about what an inquest is. But just quickly, when it says in the Magna Carta that inquests regarding life and limb shall be considered gratis and shall not be denied, what does that mean as far as a matter of life and limb? And what's an inquest? An inquest was something that a coroner had to do. Only a coroner could do it back in the, we're talking like early English jurisprudence here, everything between, well, even prior to William the Conqueror come over, because I know they were doing inquests prior to 1066. So anyway, I don't know when they actually started, but they go back quite a long ways and then come all the way forward to, all the way through till now. The process still exists. An inquest is a court process of which proves something. Go look up the court awards and liveries on Wiki sometime and take a look at, and if you have to, just pause this video right now and just go do it right now if you're listening. What you're going to find is that there was something in the court awards and liveries which was called to sue out your livery. And you'll also see that in the court awards and liveries there was what was done as a proof of age inquest. Why did someone have to do a proof of age inquest? Because what they were doing was that they were establishing the fact that they were no longer an infant. So they could hold title. So that they could sue their guardian for title of their lands and everything else they owned. Because the title was what was important to pass on to them once they'd come of full age. What is the substantive definition of the word estate? Technically, the word estate is not a thing. What it is, even though, and it's weird because this is a strange double-edged sword, because what they've done or what they do in federal bankruptcy court is they'll say this is the bankruptcy proceeding regarding the estate of such and such, right? Well, the such and such thing that they're talking about is basically a constructive trust, the all caps name. Anyway, the definition of an estate is everything that a man or woman owns in law. It's the extent of the interest that you have in something. That is your estate. Like I said, it gets used in different ways, like now, like in bankruptcy court, say that, all right, the estate of so-and-so. So now, in a lot of ways, it is kind of set up as a thing, but you don't really want to think of it as a thing. You want to think of it as the amount of interest that you have in something. And that's why the list is so long in the KW, which is the next document after the proof of life, proof of age inquest. That's why the list is so long as to all the things that you say that you claim your estate are in your estate, meaning are in only and solely your interest. You only have sole interest in all of these things that are related to or connected to your body and your property and your inheritance, because you're the sole lawful heir of your own body. And that's the other point too, because the proof of life part of the coroner inquest is that you're presumed to be dead under the Chesapeake Bay Act of 1666. And again, I totally get into that into the class. I'm not going to lay out the whole Chesapeake Bay Act and what it says and why this is important. Just as a short note, one of the presumptions is you're dead. You've been lost beyond the seas. They don't know if you are living or dead. So you have to, as per the Chesapeake Bay Act, prove in an action that you have been found to be living. These are the exact words that are in the Chesapeake Bay Act. This is why, the exact reason why I have them worded as I do in the proof of life and proof of age inquest. Do not go and change it to say, oh, I've been found alive. No. If you use the word alive, meaning a before the word life, it means away from life. If you go look it up and understand your contextual aspect of Latin. Alive means literally away from life. You have to be found to be living. Do not screw with that. I had somebody screw that up one time, and I'm like, great, you get to redo your old docs because you thought you wanted to change a word. Every single word in these documents, because they are lawful documents, have a very specific definition to them. You alter one of them, you are going to alter the entire document. Not only that, no one has the authority to change any of these documents except me, because they're all mine. Okay, just putting that out there as a fact. Don't mess with them. Yes, they're offered to you from a standpoint that I'll fill them out for you and make sure that you have them done correctly, but no one has the authority to alter these documents in any way, shape, or form. The next one. This is the BC claim. Execution of will, declaration, and claim of title. This claims your estate by way of highest claim to your birth certificate on the public record, so that all others must come forward and make a higher claim or be estopped from any administration of same. And that's what you attach to the authenticated BC that you get from the state and feds. All right, next one. The executor appointment. This appoints you as the executor or executrix, if you're female, of the estate by will under the Power of Appointment Act of 1951 and all other applicable law, so that the estate is no longer seen as not having a lawful executor or executrix. And by the way, this is the proper way to make those abbreviations. EXOR is executor, EXRX is executrix abbreviation. And you'll see these throughout the status doc sets if you've already got yours done or you're going to get them. They'll be in there. And every single place where you sign on all of the documents, you're signing as the executor or the executrix of the estate. So what this does is it ends all presumptions of any special administration or special administrator, which are the judges, in any inferior court that they have any authority over same, meaning that they have any authority over the administration of your estate. Right in here, what I have in the folders, I have the definition of administrator and I have the definition of executor, right out of Bouvier's. Go read them. Understand the difference between these two terms, why you have to be the executor or executrix and why they're an administrator. I'm not going to get into it now because I covered it in the class, but you have to understand this. Or else the executor appointment doesn't mean anything. You won't understand why you have to do it if you don't understand the difference between these two words, the definition of same. All right, next one, rescission of power of attorney. This ends all contracts, known or unknown, that have ever been created by any power of attorney over you or your estate, and any trust that derives any value from the res of your estate. And a res, an RES, is a thing. Any constructive trust that they've ever created. I don't give a damn if it's a Social Security trust. I don't give a damn if it's a constructive trust, meaning from a standpoint of creating a court case against your estate, or anything else. Any minor account that's out there, I don't care what it is. I have created this document so that it covers everything. So you don't have to keep doing these stupid things over and over and over like I've seen people do. And after you do your rescission of power of attorney, if you ever get into any court case ever again for any reason that your estate is being charged, all you have to do is drop the rescission of power of attorney into the court case and say, I am going to rescind the bond from this case. But I would announce that after you already have the bonding information by putting in a proper Open Records Request Act of your state, which we have templates for. You can have the template for free. I don't worry about that because everybody should be able to get their bonding information. But once you get the bonding information of the case, you slap that down with this, and you say, I have rescinded the bond. And none of you had any authority, to begin with, to use a power of attorney to create the bond. So it negates the whole bloody thing. That's a very important, powerful document to get the attorneys out of your estate forever. Then, the fee schedule, and here's the thing, the fee schedule and the kill warrant, I flipped these before, meaning I did the kill warrant first and the fee schedule. So these two are interchangeable as far as which one you put in the stack first. I would put the fee schedule underneath the kill warrant, which I think is how I have it in the checkoff sheet, but it's no big deal. You can do it either way. So what does the fee schedule do? All right. Fee schedule establishes lawful fees that are payable to the executor of the estate for any trespass, use, administration, and orders given from anyone other than the lawful executor of the estate, or executrix, which is you. This is a secondary contract to the KW and should be served on all trustees of the estate, meaning anybody that attempts to administer your stuff, or you can send it. Here's the thing. You can serve it to everybody before they try to administer any aspect of your estate. And then that's beautiful because they had previous knowledge, they got served with it, they got notice of it, and they chose to enter into it anyway. Now, if you thought the $300 million was bad under the kill warrant, the fee schedule is far, far worse. Far worse. We're talking about millions of dollars with the fee schedule because the fee schedule is all in lawful gold and silver. Well, it's basically all in ounces of silver, ounces of gold. And with some of these things are like 2,000 ounces of gold. Some of those things are so high because I want them to be so high that no one would ever be stupid enough to have to pay it, to be able to choose to do that thing of which is set in that fee schedule. And one of them, I think, is place any needle into me. I think that's one of the ones that's like 2,000 ounces of gold. But anyway, there's a long laundry list of various different things in the fee schedule. I'm not going to get into it. It covers like anything they could do to you, basically. Okay, then we get into the kill warrant. All right, now the proper title for this creature is lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for same. So you're doing a lawful claim of title saying, yes, I've claimed my estate, which you also can state from the fact that you've done it through the BC claim. It's a will, I mean, it's a continuation of your will. It's an execution of your will, meaning I'm executing this part of my will now because it deals with the administration of my estate. It's a declaration of status, meaning you correct your status in it. And it's an appointment of trustees, like I said, everybody who's not a member of your own house, and standing orders for them. This doc is the center of all the other status docs. It offers the office of trustee to all others in the world that are not members of your own house and gives them the terms and conditions of that appointment and the means by which they agree to them, with enforcement by binding arbitration or court of record proceedings. And as I said, this is something that Drew did, and he's got a lien on a judge's house in Colorado right now, which is recorded with the Secretary of State and is completely legitimate. Now, there was a group of less intelligent people in Colorado a while back. I believe the guy's name was Bruce Doucette and a bunch of other people. They're all sitting in federal prison right now. The reason is because they didn't listen to what I was telling them to do. Tried to contact these people, and I tried to tell them not to do certain things, and I tried to tell them how to do other things. They didn't want to listen. So they can go sit in federal prison. If someone doesn't listen to me, I don't give a damn what happens to you. I warned you. And what these idiots were doing is they were going and putting liens on judges' houses without having any documentation of law to back it up. They were saying, oh, well, they just didn't reply to our notices, so we get to put a lien on their house. What? Are you a moron? Notices are to put somebody on notice so that you can then do something in a court of record or binding arbitration. A notice itself does not adjudicate anything, ever. Period. Did they listen? No. Are they sitting in federal prison? Yeah. Is it my problem? No. People need to grow up, and they need to learn what this stuff is and what it is not. If you don't, I'm sorry. I have absolutely no sympathy for you. Particularly because I'm the one that's putting my 25 years of information up so that no one does screw it up. But you have to follow the system. There's an absolute reason why all these things are done. And I was offering this to Bruce Doucette and all those other people out there, and they didn't want it. So anyway, next one. After the KW. And like I said, the KW is the longest of all the documents. This is also the most gone over document of all the status docs. This document has gone through over 100 revisions and updates and checks, double checks and edits and whatnot. It's the most thorough document that we have in all of the rest of, not to say the rest of them aren't thorough, they're all thorough, but because this thing was so big and everything we had to do in it, it took a lot longer to perfect it. Now, originally, this document started out as one page. It was filed into a child support case. If anybody wants to see it, I put it into a wins column. It's in the very bottom of the law library. Wins of all kinds, things that worked with proof. And I believe what I put in here was, I believe I put the first, it's under redacted boom letter. That's right, I forgot what Andy called it. He called it the boom letter because it worked in one single filing and it totally ghosted the entire account. Well, it ghosted the entire case. The whole thing vanished. Anyway, I can flip through this really quick because it's only 6 pages. It's all been redacted. It was a child support thing. So what was happening was that they were trying to go after my friend's mother for back child support to his father. Trouble is that he was over 21 years old now. They send this letter and this thing to her saying that you owe this child support, whatever else. And they also sent a letter to her referring to him as an adult child. And he's like, what? He's like, oh, hell no. I'm going to take this straight to him. So he sent a notice back to him saying, I'm not an adult child. And basically, you don't have any authority to administer my mother's estate on my estate's behalf. This was the original kill warrant. This is what this thing was, the boom letter. State of Wisconsin, court, whatever. And this is what he just called it. He calls it execution of will. Day, under penalty of perjury, I, whoever, state the following of my own free will, act, and deed. I come before this court as be living, which is the other way to say it. You can say as having been found to be living or as be living, either way. And state the following. I'm the executor and beneficiary of the John Henry Doe Trust, Social Security number, blah, blah, blah. I hereby revoke any presumed or actual authority of this court and the state of Wisconsin and any other third party whatsoever to administrate my trust on my behalf as it pertains to this or any matter whatsoever, either in the past or may hereafter arise forever. This court shall order your county and any of its divisions and applicable agencies to provide me with copies of all records pertaining to this matter at my address below at their expense. Meaning, give me everything you have on this. It's not yours to administer. Number 4. Jane M. Doe, and this was the name of his mother, also known as whatever, such and such Doe Trust, is hereby and henceforth released from any liability to me or my trust whatsoever ad infinitum temporis, which basically means from wherever to wherever in the future. This court and any other party are hereby required to release and return any and all bonds created pertaining to this case to me at the address below immediately. And that was it. That's all he said. Now, of course, he'd been a student of mine for quite a while, and we had fully understood what they were doing as far as the trust relationship and probate, because we realized everything was being run through probate. So like, well, let's do this. And so he wrote this on his own volition. He mailed it to the court. He CC'd the judge in chambers. I don't think he actually served the judge. I think he just CC'd him with a green card in chambers. And he sent a copy to whatever the hell the name of the letterhead was on the top of this thing. Department of Children and Families, I guess is what it was called back then. So he sent it off, whatever, and then he waited a few days or whatever, and lo and behold, in the mail, after about, I think it was a week, his mom gets this in the mail. It's the complete accounting of the child support. Notice what it says, $10,875 over here. We were thinking this meant debt to date. The DB meant debt, and then to DT was probably date. Debt to date. So they're saying, okay, here's the debt. But look, all zeros. The balance. They zeroed out everything in this account. Zeroed it all out, and then this was all that came with that. May 31st, 2013. All balances are zero. Case will be closed in 60 days. No signature, nothing. That was all that was on that piece of paper, along with the accounting that what? He demanded that they send him. That was it. That's all he did. And then that case disappeared and we never saw it again. They ran away. So we realized, okay, that worked. Well, how do we expand this out so that it protects everybody? Because clearly they're running everything through probate. And yes, this was a matter that, he could squish because he was specifically telling them, don't go attempting to administer my mother's estate based upon my estate and trust behalf. Why? Because I'm the executor, which is what he said. Now, he said in that document, which we removed, that he was the beneficiary But he only said that he was the beneficiary of the trust because the Social Security trust name is a constructive trust that they create out of or from the productive value of the estate. So you've got the estate name, which is the all capital letters name on the birth certificate. Then you have the first, middle, last name, all capital letters, which is the constructive trust name of the Social Security account. And then sometimes you've got last name, first, middle, which is usually what they name the constructive trust in a inferior court proceeding to administer the abandoned estate through a temporary constructive trust, which is the court case itself. That's the background of the KW. So now you guys understand where that thing came from. Okay, declaration and oath of citizenship. This is something that Blue Star actually put a lot more time into and basically created on its own. I just kind of tweaked it because we wanted to have a declaration of oath of citizenship because it says, and this is connected into the 14th Amendment, which you should go read the 14th Amendment. Everybody should read it. And the other thing you should go read is you should go read the Expatriation Act. The Expatriation Act was signed, I believe, it was signed either 3 or 4 days before or after the 14th Amendment was signed and allegedly passed, which of course it wasn't passed by Congress, but that's a whole other story that I covered in another class and I'm not going to rehash it here. What it says is that you can expatriate from the United States and that you can declare your citizenship of whatever nation you want. And not to put too fine a point on it, even the filth of the United Nations has that in their chartered in their Bill of Rights, that is something that's absolutely a right to everyone, that they can choose to be a citizen of whatever nation they want to. It declares in the public record your true state citizenship and disavows any allegiance to any foreign power and the federal corporate government. This doc is used in connection with getting a state passport that does not have a social security number attached to it, which is a process that we have available. But the last person that did it, which was actually Blue Star, he had an investigator from the Secretary of State actually call him and his wife and be like, so what are you guys trying to do here? And they're like, well, we want a state passport and we want a letter of nationality, which it said on your website you guys used to do, but now you've wrapped that process into the passport application. So we want a certificate of nationality saying that we are a Michiganian, proper Michiganian, as per the United States Government Printing House style manual. That we are not a citizen of the United States, which is subject to the jurisdiction of Congress. And they went back and forth and back and forth. And we have this whole entire conversation recorded, by the way. Everything that the Secretary of State investigator kept saying was like, well, you're going to have to take that up with a judge. Well, you're going to have to take that up with a judge. Why would I have to go to a judge? I can declare who I am because it says that I have the right to declare who I am from the Expatriation Act, which is exactly what we put in the damn letter. I think the communists are starting to clamp down harder and harder, faster and faster. So I don't know 100% if we're going to be able to get them to do state passports anymore. I don't know. We'll see how everything, comes along, whatever. But the Declaration of Oath and Citizenship basically states all of the things that you are. It gives direct references to foundational documents as to how and where the verbiage is from each foundational document in reference to the status which connects to that document. So what I'm getting at is something like, if it says foundational documents say it states that you're one of the people. So we say in the Declaration of Oath and Citizenship, I am one of the people of Michigan, as per the original Michigan Constitution preamble. It's a document that just says statement after statement after statement after statement of those kinds of things, but only what you are. Because you can't prove a negative. And I've seen some people try to do this with documents regarding status. They'll say, well, I'm not a citizen of the United States, and I'm not a this, and I'm not a that, and I'm not a this. Well, you can't prove a negative. You can make a statement, make a claim, and then guess whose burden it is to prove that you're not that. It's on them. It's their burden, not yours. You say, I'm one of the people, that's it. You're one of the people. You have to prove that I'm not one of the people. It's not my problem. I'm declaring what I am. I accuse myself of being one of the people. Great, now you have to prove I'm not. Now, is there reason and logic behind that? Yes. And does there have to be reason and logic behind it? Yes, of course. If you were to say to someone, I'm a pink elephant. Well, clearly you're not an elephant, and clearly you're not the color pink. We can prove that those two things are not correct. However, when I say I am one of the people, that simply means that I'm sovereign. Now, you prove that I'm not. Can't do it. So, anyway, that's the Declaration of Oath and Citizenship. I think it's 4 or 5 pages long, something like that. But it's extremely important because it fixes the status permanently and forever. You never have to worry about your status after you do your Declaration of Oath and Citizenship, put it onto the public record. It's over. Ordinance of the estate. All this is, and I don't fill this out for people, but what I do is just give it to them and say, look, once you get all your status docs done, you get a public record number for each one of these other things above it. Get out the ordinance of the estate. You put all the public record numbers into the ordinance of the estate, and then you can use the ordinance of the estate, and then go file the ordinance of the estate on the public record. And then you can use that as basically a 2-page document to put on notice anyone who you want to put on notice of, and basically serve. You're going to want to process serve the ordinance of the estate on your state governor, your secretary of state, the attorney general, probably the treasurer, particularly if you're in Michigan, your local sheriff, your county district attorney, your county presiding judge. And then later on, when we get the templates done for it, I'll have cover letters for the DTCC, Fidelity, the DC probate court, and I know I'm forgetting like 2 or 3 other things. What we're going to do is we created the ordinance of the estate so that people who are on a budget, and I realize that a lot of people are, that it's expensive to hire process servers to go out and process serve documents on people. Usually a process server will charge you like $75 to $100, or sometimes much more, depending on how long or how far they have to travel to get a document served on someone. So, when you rack that up 4, 5, 6, 7, 8 times, you're clearly over $1,000, and so I understand that. So this kind of, the ordinance of the estate is a way that you can get the notice done to them in a way where they're not having to get served this huge stack of paperwork, which also means that you don't have to go print off or pay or go ask for certified copies from the county recorder's office with whatever the exorbitant rate they may charge to have a copy of all these things and then to go out and process serve them. Now, some people have done that, which is perfectly fine. It is the proper way to do everything 100% thoroughly so that yep, they got a copy because I have a process service affidavit that says they did, and that they got a certified copy, meaning that it was not altered or changed from what is on the public record. So that's the ordinance of the estate. The will is also not something that I fill out, and it's not even something that I give out unless people ask for it, because some people already have their wills done, but it is a general template for, a general will as to what you want to happen to your state when you pass. And I don't care if you're, 99 or 19, you should have your will done. Just have it, write it out, get it quorum signed, or if you want to, go down to the bank and have it notarized, it's fine. I don't have a problem with notarizing wills per se. Just make sure that you appoint an executor, make sure that you say to the executor what you want to have done with your stuff, and just get it done and out of the way. Because I cannot tell you how many times people have come to me and said, well, my mother had this and like that, and we, she didn't have a will, and my sister took everything from me, or our grandfather died and he had a $25 million estate and my uncle took it all. Well, God damn it, who went to the grandfather or the mother and said, where's your will? Everybody needs a copy of the will, or at least needs to have access to the copy of the will, meaning it needs to be filed, and this is the only time I would ever use a attorney firm for any reason, is to file a will with an attorney firm. Because they are under lawful contract to then produce it and do exactly what it says in the will. Another thing, this is another situation where, Noah didn't build the ark after it started raining, okay? Get your shit done. All right, now the rest of these things have nothing to do with the status docs. They're just other things that are available. But I do give people a copy. And if they want, they can tell me if they have a special master or they know who they want as their marshal. That's fine. I'll fill out a special master appointment and a marshal appointment form. But special master appoints others as special masters to your court of record. In the event that you are arrested for any reason on statutory charges and need someone to file a constitutional not statutory, habeas corpus in a court of record at law for your immediate freedom from the corporate court and filthy jail that is attached thereto. Marshal appointment. Appoints others as marshals of your superior court of record for enforcement of the judgments and writs of that court, as well as for being a process server who is an appointed member of your court. Special masters can also process serve because anybody over the age of 18 can process serve. So, and then we've got the passport application, which I said. Then we've got the change of address, which is something that I can just tell you how to do it, but I don't really have a form for it. It's something you have to go down and talk to your local postmaster. The IRS, the SS4 form for the 32 estate EIN. This is something also that's been kind of bouncing back and forth or bouncing back to us. I've got a few more letters that I need to write. And this is for anybody that might be listening that has done this already, that did the 32 EIN. If you got a letter back saying that something like, oh, the so-and-so has to be a decedent or whatever, basically what you simply put in a letter back to them is you say, look, isn't it stated that under your IRS master file, this name, this person is listed as a decedent in the master file? ? So I demand that the SS4 form and the 32 estate EIN number issue, because it's a matter of law that it issue, because yes, the estate is a decedent and you have it that way. And if you want to, the other way to do that, and what we may have to do now, which is just more stupid hoops to jump through for the Khazarian mob, we may have to hit the IRS up with a Public Records Request Act, Sunshine Law Act, FOIA, whatever, that we specifically demand our entire IRS master file. And then simply find it in the master file. We're labeled it as a decedent. Take a copy of that out, then send in the SS32 EIN estate number and say, look, it's in your own records that this thing's a decedent. Now, give me the damn number. That's a possibility of what we might have to do there. And then the declaration of lodial lands is if you have land and you want to declare it to be a lodial and get it off the tax rolls. That's that. Now, that's the general sheet. Now, I have this one also. I'm not going to go through all this, but you guys are welcome to take a look at this as far as the master list of the process to sue out delivery, which is pretty much everything I just said. But there is some other added information in here about what some of this stuff does. But it's more or less what I just read until you get down to the bottom about what we're doing down here as far as suing out for the estate. Now, this process is not finished. I'm working with a couple other people about how we want to do this. But we're going to do probate in common form, also known as common probate or formal probate, also known as uncontested probate, is the form of probate we seek to enter into as far as where we're going to put and file all of our status docs and say, we are here to settle this estate. Right? I'm the executor and so on and so forth. And then what we want to do also is to get letters executor from one of their inferior equity courts as well, which shouldn't be a problem based upon what we're doing. But anyway, and this is how I intended to do it. This process might change slightly. And then other things to be done are other side matters and things that I have in here about possibilities of other things that we can do or we need to look into how we can or should do. And as I said, some of these things, I put not sure if necessary, like, the copywriting of the name, is that necessary? But at least I put some of the general notes in here. And then these are some of the places where I'm talking about as far as serving are concerned with the status docs. Tammy used to call these the 6 E4s, which are the 6 major departments of the U.S. government. So so that's all the rest of that doc is. And then just a printable checkoff sheet. This is also available on the mega link. This is just a checkoff sheet. It has all of the things down the side, except it doesn't have the descriptions in here. But this is what you want to print off. So when you start doing your doc set, you're like, okay, yep, got this completed. Okay, yep, got that done. Okay, got that done. All right, this is the date I recorded it. This is the county recorder's number. This is the state where the document was recorded and the fact that I got it done. And here's my checkbox at the end. Cha-ching, right? It's just a simple checkoff sheet that I made for people that might have a problem with organization. I've organized it for you. So it's just an easy thing to print off and check and get done. So if you guys want to ask any questions, you can unmute yourself and go ahead and ask. Or like I said, if you got any questions you want to put into type, you can put them down. Looks like Ron said, if and when we have a will in place, wouldn't that also protect the named individual in certain matters? Yeah, well, that's the point. That's what the status doc set is. The status doc is, all of the status docs are a continuation of your will. Because that's what they've done. They've stolen our will. They've probated your will. All of your estate is running around in probate. They're just administering it. If you look up the Uniform Probate Code for all the states, which comes from the filthy uniform state law commission out of Chicago. What you'll find is that they call the judges special administrators. That's what they are. So like I said, anybody can feel free to unmute and ask a question if you want to. There's 3 different forms of the executor/executrix appointment. Either one, the wife is coming under the house of the husband. Basically, that means the husband has to do the doc set too. And that it's under his house that she's coming under. And in that particular executrix document, that the husband takes the wife as what's called a special deposit. We're all being special deposits in these courts. Our bodies are basically special deposits in these courts as part of the res of the estate. So what we're doing is we're saying, okay, look, the body of the wife is going under the protection of the man's house. And then she signs it. Where she signs the document is kind of like in the middle of the document, where she signs her proper name, just first middle, not and also house of whatever, because technically she's not of the house of yet until that document has been publicly recorded. So as far as the time frame is concerned, she signs it just first middle name. So first hyphen middle name as special deposit, which you don't have to write that in. That's already in the sentence. And then when that document gets filed onto the public record, then the woman has entered the man's house. And he's the one that signs and seals the bottom of it, agreeing to that marriage. And technically, I mean, if you really want to get technical about it, that status doc is honestly the most solid common law way to be married. It is literally your new marriage contract. And then so the other 2 that aren't that one is either if a woman is not married, she wants to create her own house, she can create her own seal, create her own house, do her own thing, and be her own executrix. Perfectly fine. Or, again, if it's just a single male, then obviously the same thing attaches and he creates his own house and then he's the executor instead of the executrix. That's that. Okay, so Carrie, if he's not ready to do the process, you can just establish your own house and you can... Oh, the other thing that I was going to mention, because you mentioned children. The other thing that goes along with the lawful claim of title, execution of will, declaration of status, appointment of trustees, and standing order for same. The other thing that goes along with the kill warrant is a separate document, if you have children, that you describe your children, and basically in the kind of the same way that they do for state identification, so on and so forth. What you do then is then someone is finally claiming the children from the original abandonment at the Foundling Hospital. That's an attachment that goes along with the kill warrant if you have children. Okay, so that answers your question there. Not grandchildren, Chief, just the children. And here's the thing. There's no reason to claim any children who have already reached the age of their Roman civil law term of reached the age of majority. So anyone that's over 18, you don't need to claim anyway. You're just doing your own doc set, doing your own thing. If you're doing this, then you should teach your children how to do it because they're the ones that have to come and claim their own estate. Honestly, the most ideal period of time for anyone to do their doc set would be after they've reached the age of 18, but before they turn 21. Now, here's the thing. It's not lawful at all as far as what they're trying to do, but there's a sneaky thing that they have in U.S. code that says that, and it's about a presumption. Again, it's just presumption. It says that if someone has not basically declared themselves to be of basically a de jure state citizen or not being a citizen of the United States, that when they turn 21, the presumption is that they're a citizen of the United States. Which, like I said, is one of these sneaky things that the attorneys wrote to try to put the presumption in there that we're all subject to the jurisdiction of Congress, which is exactly what it says under the 14th Amendment, that you're born or naturalized and subject to the jurisdiction of Congress. That's a citizen of the United States. So what if you're born or naturalized and not subject to the jurisdiction of Congress? Well, you're not a citizen of the United States. But the best time to take care of that is technically between the ages of 18 and 21, because that 21 is the age when they say that quote-unquote presumption kicks in. But I don't care about their presumption. It's not valid. It is just a presumption. And of course, when you're the trier of fact in your proof of life and proof of age inquest, well, technically the jury is the trier of fact. But the point is that when a trier of fact, the judicial part of the court itself, meaning the part of the court that's the tribunal, is the best way to say that. Once the tribunal decides something as what is or what is not a fact, that's the end of it. So all the presumptions get erased anyway. So we erase the presumptions with the coroner proof of life, proof of age inquest. So I don't care about the 21 thing. Okay, so next question. If any one of us were to be arrested, whom would any one of us contact to get us out if the cops and judges won't pay a mind to our paperwork file? You contact your special master. When you've appointed a special master of your superior court and you have it signed and you have it sealed, all they have to do is go down and get a certified copy of the special master appointment out of the public record, file it into the court, and then that special master can enter into your court and file a habeas corpus on his or her sovereign's behalf, basically, and can run the whole entire court. Your special master can run your superior court of record without you being there. That's the point. Because special masters are basically a judge. They're basically like a judge without the pay. And how they use them in U.S. District Court and regarding the Federal Rules of Civil Procedure is that you'll have special masters assigned to very, very large cases that usually like class action lawsuits where you've got hundreds and hundreds and hundreds of litigants in there. And usually special masters are assigned to deal with the ridiculous accounting headache that comes along with a case that big. But you can appoint a special master for your court of record as well. So, and yes, Kara, you do have to have someone. Do not pick someone as your special master who doesn't A, know the law, B, understand how to run courts of record, C, doesn't know what this process is, or D, is unorganized. But if it's someone you trust, someone who knows the process, someone who knows about courts of record, and someone who knows how to file a proper constitutional habeas corpus, then yeah, you should appoint them as your special master. Yeah, the other section of your question, Kev, about they have the keys, they don't think they'd acknowledge our rights. Well, here's the deal. If you file a proper constitutionally based habeas corpus, not meaning you're not filing a statutory based habeas corpus, meaning you don't use the statutes, the habeas corpus statutes to say, I'm filing this habeas corpus under such and such statute. No. You say, I'm filing this habeas corpus as per the Constitution, federal and state constitution, sections of the federal state constitution, and I'm demanding that the state of Utah or wherever it is you live produce not the body of the accused, but demand that they produce the damaged party. Demand that they produce the body of the damaged party, because that's what habeas corpus means. It means produce the body. So in writing your habeas corpus, just demand that they produce the damaged party. And if they can't do it, then they've got to let the other guy out. Now here's the thing. If he hasn't done a damage, harm, loss, or injury to anyone, there isn't going to be a damaged party. So you can't produce the state of Wisconsin on the stand and say, here, state of Wisconsin, take the stand. Can't do it. It's fictional law. There's another maxim of law that says that where truth exists, fiction of law does not exist. Now that's a really important maxim to remember, because where truth exists, fiction of law does not exist. You are the truth. You are a special master standing there as a man or woman in a court of record, which, okay, that technically is a kind of a fictional thing. The point is that it's the sovereign's court, and the special master is there in their capacity to run that court and to adjudicate the habeas corpus as per how the habeas corpus is written. When you do it that way and you file the habeas corpus in like every single inferior court and your superior court of record and even send it to the Supreme Court, trust me, they're going to pay attention, because they have in the past. They don't screw around with that. So anybody else got any other questions? Okay, so Chief, you said I'm guessing you say if we have our DocSet file, and then we are arrested for not having a driver's license and have our private automobile impounded since it's not registered with the corporate state, what then is the proper procedure if they ignore the special master? Well, if they ignore a habeas corpus, which they won't, because you'll file it in every single court in the land, it's by right. I mean, it's a high prerogative writ that you have the right to file. And like I said, if you do it constitutionally, they won't ignore it. If you do it statutorily, they will. They'll be like, oh, you filed it under this statute. No, it's under our discretion. We don't care. Dismissed. But of course, the thing about, not having a driver's license or not, all of that, again, is the same situation where you want to have your ducks in a row before you ever run into that situation, meaning you want to do the whole process of sending the notices to the Secretary of State saying, do you have any interest in this, in my property? And then, give them the VIN number of the car or whatever, and do a 3-notice process, and then have a notary default them. And then you take that's called an administrative process. So you do the administrative process, and then what you do is you go to, and this is the only time I would really use an equity court, is that you go to an equity court and you file for a declaratory judgment. All a declaratory judgment is that it's not for any monetary damages. All it is to establish the relationship between the parties, or to establish the status of the parties, or, so on and so forth. So you ask for the declaratory judgment from the court for them to just simply sign off on the fact that the state of Utah or the state of California does not have any interest in your property. That's it. And then you just carry the declaratory judgment around in your glove box. And if you ever get pulled over, you give them the declaratory judgment. You're like, here, get out of my face. A judge has said that this is my property, not the property of the state. What do you want? I'm not engaged in commerce. So then, A, they can't impound your car. 2, they can't write you a ticket. And 3, they'll basically fuck off, which is what they should do. Because you say to them flat out, I don't have any contracts with you. What are you bothering me for? Well, I mean, you can do it at the same time. I mean, the question is, okay, the doc set and all the follow-up administrative things should have been done before we turn in our driver's license and unregister our private automobile. The thing about, there is no way to unregister the thing. What you have to do is go through, like I said, go through that process of the administrative process to get the state under a declaratory judgment that they don't have an interest in your property, because you can't really unregister a car. Once that bell's been rung, you can't unring the bell. But what you can do is the other thing. And then as far as your license is concerned, you don't say turn in your driver's license. What you say is, the proper term is you surrender it. You surrender it to them. It's like, here, I don't need this thing. I'm surrendering it to you. I'm being a good little enemy combatant, and I'm surrendering this license to you because I don't have any use for it. I don't use the roadways as a place of business. Then what you can do is you can just use your status doc set as your identification, basically. Or if you want to, as long as you can get one that doesn't have a social security number attached to it. You can get a state ID without a social security number attached to it, I believe. Yeah, actually, there's a couple guys that I know have done that. All they did was they took in their birth certificate, and you could take in the birth certificate too that's attached, you get back, that's authenticated. When you get the BC back, authenticated on both the state and federal level, there's instructions, which are in the handbills. There's a very specific endorsement that you need to write on the back side of the BC, and then sign and seal it in the corner, in the lower right-hand corner. And basically what that is that you're endorsing the check, because literally that's what they call the birth certificates. They call them checks. You're endorsing the check properly to yourself and and that the estate is being assigned to you and not to any other third party. So then you could just literally hand that to the cop and be like, I was born one of the people of California. I've endorsed this check. Again, what do you want? Like, why are you bothering me? Question was some people teach that we write on the back of the birth certificate and send it to the federal Secretary of State, pay to the order of. No, if you're turning around, anybody that ever came up with that idiotic process is simply, again, doing the exact same thing that they did when they went to go get a stupid driver's license to begin with. What they're doing is they're turning around and they're giving the title of the thing right back to the corporate state. I'm not allowing the corporate state to use my credit, bond my productive value, use my productive value or my estate as collateral for loans from a private cartel called the Federal Reserve, because that's what the Secretary of State is doing. They're taking private loans from a private cartel and they're using you as collateral for that. If whoever came up with that idiotic idea understood that, then what they were doing was they were going right along with the system. I'm not going along with the system. I don't want anything to do with the filthy Roman civil law system. So no, I would never write on the back of the check, pay to the order of them. The way I do the endorsement on the back of the BC says that all of the res of the estate is now reallocated to the executor of the estate, which is you. So you take control of the whole entire estate by writing the endorsement properly on the back side of the BC. Yeah, I've heard of the process where like they send it to the Secretary of State or they send it to the Treasury and say, "Oh, pay the order." Blah, blah, blah. No, that's again absolute wrong thing to do. If you want to get out of Babylon, claim your estate. If you don't, well, then take your snippet and your be a beneficiary and wear your chains of gold. I don't care. I mean, it's up to you. No, I would never do that. I would never write pay to the order of and then give it to the treasurer because what you're doing is that then, uh, and again, here's the thing: even if you did something like that, like say somebody did that, they if they haven't done the coroner life and proof of age inquest anyway, they're just an infant. They're still just an infant. So it's an infant like saying to daddy, "Okay, daddy, I agree with your rules." Or, "Okay, daddy, you can go give the Khazarian mob my credit so you can keep running your bankrupt corporation." Yeah, no, I'm not doing that. It's the system needs to end. Absolutely needs to end. But it needs to end for the right reasons, the lawful reasons, as which is why I created the doc set. I'd better cut it off for the night. And so thank everybody. Thank all you guys for coming. Thanks for your questions. And of course, if you got any more questions about anything that come up later, you can always send me a DM in Gilded. Just again, make sure that you go into the VSOF section under VSOF information, click on correct your status, then click on how to get your status corrected on the public record. And then when you do that, you scroll down and you'll see in really big, bold, white print all of the classes that I did for the status docs class. And everything else is explained in much more detail the whole day. I asked that everybody go through that. And I did do another smaller little class, kind of like this, but not to this level of detail under class 4. And I put the link also in that section as well. So you guys can go check those out too before, if you think I might have missed anything. So with that, I thank all you guys for coming, and I'll see you all on Saturday.